Today's panel will test whether the water tightness of a resolution plan is really a legal reality or is it just a commercial illusion. We'll start off by introducing our hosts. The Insolvency Law Academy, for whoever doesn't know about it. It'll be blasphemous for me to speak about it when we have Mr. Batra here himself. So I'll let him introduce the academy and then we'll move on further.
Thank you so much, Vishshrutyi, and of course, a very good evening to the panel and to all the participants. First of all, I wanted to sort of thank IWIRC to sort of partner with us on this. Uh, it is one of the fastest growing organizations across the world, and I can only see this going better and better and stronger and stronger. Something that was long due and awaited. When Julie Herzberg became the president of Insolvency International, we sort of she sort of broke the glass ceiling, becoming the president of one of the most first women president of one of the most formidable organizations in the world, and I see that this is a trend that will continue across different organizations. And I look forward to a day when ILA will be headed by a woman as well. Um, ILA is an institute of excellence. We are uh, a research center, um, a kind of a thought leader. But if I have to tell you two things that sort of drive me and in turn therefore the ILA, because we're in the initial years and I'm sort of the president in the foundational years, trying to sort of set the philosophy of the organization and also set the narrative for what we uh, are, is that we want to help develop a fraternity of scholars in the country and beyond. I am committed to developing it from the youngest level to the most sophisticated level, the finest scholars to come out of the country and contribute to the development of the global insolvency ecosystem. And we will do whatever is possible within our means to make that a success and a possibility. Second is to the extent possible help the government handhold on in making our insolvency system as robust as possible so that we can contribute effectively in the national aspiration of becoming a developed country by 2047. These two are, if I may say very, very briefly, without going any further into uh, what we are, I mean, you can just see our website and follow us on the LinkedIn and you would get to know the activities that we do. Only one 30-second note that I'd like to make is on the topic of this session, which you, Vishshrutyi, were just touching. And I think it's a very, very important topic that you have all picked up. And I really would be looking forward to also listening to you with my video of the, because I believe that this is going to be the central narrative of the next 1 year, if not more. This is something after the JTB's judgment caught the uh, attention of the policymakers as something that is needed as a big gap which needs to be plugged. Those in the practice are mindful that this has been offering many challenges and has also been a very significant reason for the delays in the implementation of the plan, and therefore bringing a bit of a disrepute to the insolvency. And we're hoping that through the various best practices, the legislative changes perhaps, but certainly the regulatory changes, and also how the judges would respond to these resolution plans that are approved, or even before they are approved, in order to make sure that they can be effectively implemented, is something that we'll have to very closely watch. And the whole idea, therefore, would be actually to try and achieve, which is one of the possibilities that you're discussing today, which is to make the water resolution plan as watertight as possible. Of course, by staying in the realm of reality, but at the same point of time, making sure that we do not have any possibilities of setbacks of the kinds that we've experienced where plans are disapproved after years by a high court or by the failure of the resolution applicants to implement the plan or some disruption caused by some other stakeholder. And I really am looking forward to listening to all of you. And as Aila always does, whenever we do an event such as this one, we do make notes, prepare a short note, and then share it with the government so that the echo of what you say can be heard in the policy corridors as well. And to that extent, we'll prepare a synthesis note, share with all of you, and send it to the government as well so that they understand the sentiment of the public. Thank you so much. Apology for a rather longish comment, Vishshrutyi, but wish the panel all the best.
Thank you so much. Your views are always welcome. And thank you for opening the topic for the entire webinar. Before we move to the topic, I'll just do a quick round of introductions of the members on the panel today. While none of them really need an introduction and each of their reputation precedes all of them, I'll go one by one. We have Surbhi Pareek from CAM. She's a partner at CAM. We have Neeha Nagpal, who's the founder of NM Law Chambers. We have Eshna Kumar, who is founder of Chambers of Eshna Kumar. And we have Ishana Tripathi, who is an associate professor at the OP Jindal University. While Mr. Bhatta has already set the tone for the topic, we did think that this topic was very large, very overarching, and a lot of components which needed to be put into a capsule within this 1 hour. The panel decided to categorize them into 3 sharp columns or 3 sharp categories, each of which will be picked up, debated in parts. We have decided to break the panel into 2 teams. One team will be for the motion. The second team will be against the motion. We have Surbhi and Neeha, who will be for the motion. And we have Ishana and Eshna, who will be against the motion. So that being said, I think the floor is open for discussion. And just opening it up to the panelists, just as a thought for somebody who's, we're all practitioners, we've all been reading in and dwelling into the developments of judicial interventions into resolution plans. But a plan is only as watertight as the system in which it sails. So what is it? Is it truly a myth for us to have a watertight resolution plan, or is it just a poorly implemented reality? And to answer that in a more formalized manner, I'd like to address the most obvious thing or the most obvious provision of law that each of us think about when it comes to the watertightness of a resolution plan is Section 32A. We understand that it aims to ring fence resolution plans from criminal liability of offenses that are in the pre-CIRP period or prior to the CIRP of the corporate debtor. However, in practice, we've all been seeing that the power of the agencies like the Enforcement Directorate to attach assets under the PMLA continue to cast a shadow on the post-resolution framework or the post-resolution process as well. So that begs the question for the floor today is that does Section 32A of the IBC provide adequate protection to resolution applicants to ensure that a resolution plan remains truly effective and final? That's the question, that's the proposition I open to the panelists. We'll ask the first team that is for the motion, which is Surbhi and Neeha, to address their arguments on this. We'll be allotting a total of 5 minutes to each side. Both team members can decide within themselves how long they would like to make their submissions on this. We will then move to the other side. In case either party wants a rebuttal, you can ask for it, after which we will close for polls on the proposition. To you, Neha and Surbhi.
Thank you for that. I think you've raised a very important question. I have had the privilege of having 2 roundtables with ILA on largely, the area of 32A. I think it's it is the need of the hour that needs to be addressed. There are 2 ways of looking at this. One is simply an overlap between PMLA and ED, which we are not doing today. The second question is, of course, the second way of looking at it is the effectiveness and the watertightness of a resolution plan. I'm a firm believer, I have a lot of faith in the Insolvency and Bankruptcy Code. I feel that it was brought about with a very noble objective. It was also brought about, more particularly, as much as I know, a lot of us have very different and divergent views in 29A. But I think to some extent that was also has been effective and useful. It sends a very strong message to errant promoters that, listen, there's a limit and don't cross that maryada. Having said that, in light of that, somebody who is coming in to acquire a company is obviously coming in with knowing the rights, the wrongs, weighing the pros and cons. They obviously submit a plan which will be economically beneficial to them to take over this entity. For example, let's discuss Bhushan Power and Steel, JSW's takeover. In that period, while the company, or for that matter, SR Steel and ArcelorMittal, in the period of CIRP alone, SR Steel had made 15,000 crores. So by the time the Lakshmi Mittal, sorry, ArcelorMittal took over the company, even though they may have spent in excess of 37,000, 47,000, 42,000 crores to get the company, they were actually at a profit in some manner of speaking. So obviously these are valuable assets we're talking about. And you're talking about wolves coming in. There are no lame ducks who are coming in to today buy these companies. So they know what they're doing, whether it's economically, whether it's their management, whether it's their resources. They have a solid plan. They are backed up. And let's not discredit our COCs. To be able to gauge the effectiveness. Now, today, the question of the ability of the COC is in doubt and question. I'm not dealing with that. But I am reposing complete faith in the watertightness, effectiveness, correctness of a resolution plan, more particularly one that meets the test of Section 31 and the requirements under Regulation 38 at the level of COC and at the level of NCLT. The problem now is the intention of an act like IBC, or be it the Benami Act, or be it the Fugitive Economic Offenders Act, or to some extent Sarfezi, and juxtapose that against the Insolvency Code. What does everybody want? Everybody wants their money. Everybody is looking for to get the maximum that they can get out of this failing asset. Nobody would go invoke their Sarfezi right if there was not a default. If there wasn't a default, there wouldn't have been an NPA. Insolvency wouldn't have come in. If there wasn't a default, if there wasn't a declaration of fraud at the level of a company, there wouldn't be fraud declaration, CBI, ED, etc., etc. So everybody wants to maximize the money. Where does the money ultimately go? Back into the economy. So I think there has to be this mutual understanding between the agencies and between I guess between the agencies and the government will have to at some point intervene and clarify the position. We have enough laws protecting everybody. Today, even 32A, whilst the course in November of 2019 to be made effective during the course of Bhushan Power and Steel's insolvency process, which was pending challenge at NCLAT, was with the intent of making that resolution plan as effective as possible, to be able to give back to the COC and therefore the economy as early as possible. Therefore, 32A. I really, really do believe that once we read in a mechanism into the Section 31, there are two things actually. One, reading in a mechanism into Section 31 of the code to say that the plan is now passed. In case there are any ED attachments, they, by operation of law, will stand vacated qua the corporate debtor. We don't care about the erstwhile promoter, because then that is in tandem with 29A. The second is an information sharing arrangement between the IBBI and maybe the ED, SFIO, or whatever other investigative agencies, so that the assets of the corporate debtor remain protected, thereby supporting the effectiveness and effective implementation of a corporate resolution plan. I guess I'd leave it to that and let Surbhi come in there.
Thank you, Neeha. Thank you, Vishshrutyi. And thank you to ILA and IWIRC to have this wonderful topic of discussion, which I think has an impact for all of us. I have a couple of points to make. I'm a believer that I think 32A does give what we require as of now. There are three arguments to that effect. One is that we need to say the timeline at which stage the protection is accorded and for which period does it pertain to. So when we look at any offense, then offense has to be committed prior to the commencement of CIRP. To that extent, there are adequate carve-outs, and the protection kicks in once the resolution plan has been approved by the NCLT. Now, I think it has been very beautifully put in by the Supreme Court when they were looking at it in Manish Kumar Jain versus Union of India, when the constitutional validity of the provision was upheld. The court, and I quote, having regard to the objects of the court, the experience of working of the court, and the interest of all stakeholders, including most importantly, the need to attract resolution applicants who would not shy away from offering reasonable and fair value. If the legislature thought that the immunity be granted to the corporate debtor, it hardly furnishes a ground for this court to interfere. So the reason at that stage the court thought it was not prudent to interfere, they have gone back into the basics of it, and we must appreciate that if we look at other jurisdictions, we don't see a similar provision. And if we interact with other practitioners in other jurisdictions, something similar has not been done so far. I think what the legislature has done, and like I said, the Supreme Court has also articulated in similar way, that there is a protection which is accorded, but the protection kicks in when the resolution plan has been approved. There are certain concerns that have been raised. The second part of my argument is basically that there are certain concerns which have been raised because of the observations made in the recent judgment of Bush and Power in respect of interference by the adjudicating authority in respect of the PMLA provisional attachment orders that may have been passed. I think while given that there's a status quo, I don't want to go into the merits of the judgment, but at the same time, we need to also see that stops when effectively the judgment does not go into the fact that there is still a protection once the plan is approved. And now we have managed to get a similar order where a provisional attachment order was passed, and NCLT Mumbai was kind enough to taking into account the fact that they cannot interfere with the provisional attachment order. They have observed that the protection accorded under 32A will kick in because the plan has been approved. So I think if there are adequate provisions which are stipulated in the plan, which talks about and handles the criminal offense liability not be extended to the resolution applicant or the successor in interest, then in that case, it can be a watertight resolution plan and that protection will kick in. So this is my limited submission. I will want to hear Ishana and Eshna.
Right. Thank you, Vishshrutyi, for that. And thank you, Neha and Surbhi. I will be against the motion saying that a resolution plan is not watertight, and it being a watertight resolution plan is surely a myth. And I would be taking 5 minutes in order to address this issue. So here we're looking at Prevention of Money Laundering Act 2002. And we're looking at Insolvency and Bankruptcy Code 2016. One is in order to look at seizing of property for a wrongdoing of an owner. And for the insolvency, we're looking at resolution of a company, ensuring that secured creditors get their due to the maximum value. The conflict, the loggerheads, is quite clear because and that is what I think really ensures that the resolution plan is not watertight because of the conflict and the clash. The contrasting claims of secured creditors who have legitimate charge over the asset as against the enforcement agencies who aim to seize that very property results into rather than maximization of value of asset, I would say deterioration of value of asset. Any person who wants to take over a company would, like we would be discussing later, would want a clean slate. A clean slate would always and always mean that that clean slate is not only with regard to the criminal liabilities, but also with regard to civil liabilities, meaning thereby that their properties which they are taking over should not tomorrow be taken over, or should not tomorrow be in a manner that it is contingent that the agencies can come against them. So in my submission, 32A may academically and on the book of the code give that protection, but practically it is not. Also, let's look at this. The objective of the code was to maximize the value, like I said. Now, when we looked at the entire regime of PMLA vis-a-vis IBC, Section 14 of the Insolvency and Bankruptcy Code, which talks about moratorium, does not cover this. We have had discussions starting from the Honorable NCLAT in the Varsana Ispat Limited judgment, going up to the Rotomac Global Private Limited judgment. And then, of course, we had one ray of hope which said otherwise in the Manoj Kumar Agarwal judgment, which is very short-lived and immediately got clarified in the Kiran Shah 3-judge bench NCLAT judgment. With that behind us, and with the Delhi High Court judgment in Rajiv Chakrabarti, that behind us, saying that Section 14 will not be applicable in cases of PMLA is the core of the difficulty of the resolution plan never being a watertight one. Because any person who will be giving it will always be contingent on the fact that the value of this property is either unknown, or these are subject to maybe preferential, undervalued, extortionate, or fraudulent transactions, which when we will get it, we will see. And the properties also they are taking over is something that is that the value could be deteriorated at any time. So why, I mean, the first step itself of the preparation of the information memorandum becomes vague. A resolution plan coming in becomes vague. A resolution plan, if comes in, the implementation of it becomes vague. So in my very, very respectful submission, and number one, IBC and PMLA are 100% acting in their own domains of special law. The PMLA in one, the IBC in the other. Both have their non-obstant clauses under Section 71 of PMLA and under Section 238 of IBC. But the question is the contrasting claims, the conflicting claims for the same asset which is to be taken over for the purpose of the resolution or for the purpose of holding the owner to be guilty seems to be same. And I believe, as on date, there is no judgment which clarifies the position as to which overrides the other, except the Bombay High Court judgment, which was a kind of a light in that entire darkness, which was very, very, quickly stayed by the Supreme Court, that is the Shiv Charan judgment. Secondly, having said on the issue of the maximization, on the criminality of the PMLA not allowing the overriding effect to be clarified, and thirdly, I would say that the fact that NCLT, which is what Kalyani also holds, and indirectly in my reading overrules the judgment of Shiv Sharan, is the fact that today NCLT is devoid of the jurisdiction to even look into this issue. Today, an SRA, despite an order being in its favor of approval of resolution plan, even maybe having a paragraph or a finding of 32A stating that allows it to not have any culpability with regard to the wrongdoing of the earlier management, may have to end up facing consequences not in NCLT, not being able to go back to NCLT, but to go to a different court because of what I see as, because of the judgment of paragraph 27 of the Kalyani Transco judgment. So today, despite the fact that would be a stay, and I hope that till the time the law is that the proceedings of PMLA, despite the fact that it's an earlier law of 2002, are going parallel to IBC. Even if Kalyani Transco today is overruled, we are in a position that IBC and PMLA will go parallel. Until the time there is not a clear judgment, there is not a clear amendment to state that PMLA is something that is, IBC is something that supersedes PMLA. And even if it is harmonious, 32A will, read with 63 of IBC. Mind you, 63 of IBC specifically excludes jurisdiction of PMLA courts and allows NCLT. And Kalyani Transco doesn't even look at that. It doesn't even consider Section 63. So here, faced with a situation where I do not know what the value of the property is, having known, if at all, the value of the property, I don't know whether that would go back to the government agencies. A watertight resolution plan seems like a myth. That's it. I ended at that on this issue.
So would Surbhi or Neeha like to rebuttal? We have 1 minute for rebuttal.
So I'd like to come in there to say I agree with, and I hear Eshna with whatever she's saying. There are those, if I can term them as logistical issues today. Why do I say logistical? Because they are who comes first, who comes second, who has precedence. They both have non-obstinate clauses. PMLA, in a manner of speaking, has in many cases they say, but our investigation started earlier, but CIRP happened later. Shiv Charan was actually, Justice Som Subramaniam Sundareshan's judgment was actually a very defining moment. I agree. It was really ray of sunlight that we all needed, that clarity. Despite the upholding Section 32A in Manish Kumar's judgment, we still had issues. Then there was that issue. Then, strangely, again, coming back to Bhushan Power and Steel's case, last December, 11th December 2024, suddenly ED took a position that we are disattaching the assets in this case, but we are limiting it to the facts of this case. But the question around 32A is left open. The virtual stay on Shiv Charan and the findings by Justice Bela Trivedi in the Bhushan Power and Steel case sort of extend the stalemate. My own sense to that is that does not, in the long run, create an impediment for a watertight resolution plan. At best, there must be a delta of, say, 5 to 7%, which is again huge in numbers, where there are PMLA issues and where there are CIRP is happening. But that doesn't take away from the majority of cases where we have seen successful implementation. Even in the dirty dozen, either by way of liquidation or by resolution. So I'm hopeful that these logistical temporary issues will be addressed. I agree that in Kalyani Transco Bhushan Power and Steel's case, Justice Trivedi has observed embassy properties and said you have to go to a writ court. I don't think we need to burden an SRA with that. I think deeming fiction in Section 31 by way of clarification or amendment to the code would suffice. And that once taken care of, I think there would be an alignment between the objective of PMLA and the insolvency code. I mean, if Surbhi has something to add to that.
I think I agree with exactly what Neeha said, that practical difficulties, yes, that's absolutely appreciated. And that is something that needs to be addressed. But does that become an impediment for a watertight resolution plan? I don't think so. As in, there are issues that needs to be addressed either by way of a statutory amendment or otherwise. But that being said, I think the SRAs should have clarity, or we should be able to give them comfort that there is a protection which is given and embedded in the legislation itself that takes care of their concern. So yeah, that's my rebuttal. Thanks.
Okay, thank you for that. But what a lot of this discussion leaves me a little confused and perplexed about is we've spoken about PMLA, we've spoken about ED, we've spoken about the attachment, we've spoken about the claims there. But let me put that as one aspect of it. There are persistent challenges in the insolvency resolution dealing with liabilities that are disputed, claims that are contingent, claims that are yet to be crystallized. May they be arising out of an unresolved contractual claim, may it be arising out of a regulatory proceeding or an arbitration proceeding. And that begs me to where I'm leading to my second question as to do resolution plans provide finality and certainty to the treatment or say the exclusion of such claims which are often bound to have a contingency attached to it? Doesn't that go to the root of the completeness and the enforceability of the plan? And I open the debate to the panel on my second issue or the second proposition as to whether can a resolution plan be considered truly comprehensive and final if it does not account for pending arbitrations and contingent liabilities that may be crystallized post the approval. Again, we have Surbhi and Neeha who are for the motion, and we have Ishana and Eshna who are against the motion. So I open the floor to the panelists.
Surbhi,
Yeah.
would you like to
Okay.
take that?
Sure. I think I wanted to cover a couple of practical issues that have been they are, I think, the reason for this issue coming up. I think in respect of contingent liability, the very first instance that comes to the mind is the SR Steel judgment, where there were certain litigations which were pending and the claim value was admitted at a notional value. While the Supreme Court sort of took cognizance of the fact that given that the claim were disputed, the admission of those claims at a notional value was correct. And also they said that there is a fresh slate start for a corporate debtor. The subsequent events in respect of how it will be, because the litigation still continues, the enforceability of those litigation then becomes questionable. And I think that also flows in to the other subsequent judgments. So the real challenge, while I taking a cue from what Eshna covered earlier, there are, I think, still practical issues. Yes, that is very well accepted. But at the same time, I don't think there is any dispute or ambiguity when it comes to taking into account the fact that any litigation or any arbitration or any contingent liability for that matter will not survive after the resolution plan has been approved. And that has been reiterated by the courts in subsequent judgments multiple times. What does although happens, like we have seen instances where electricity department will continue to challenge, ask for their claims even during pertaining to the period pre-CIRP, etc. But that's a difficulty, and that may have to be taken into account when the resolution applicants put forward their plan. That's a risk factor and may be appropriately priced in the resolution amount that is being proposed. But I think for what is required from an insolvency and restructuring regime in terms of certainty and predictability, at least on this particular aspect, that there will be extinguishment of liability or there will be a fresh slate start for a corporate debtor. I think to that extent, there is certainty. And I think I will let Neha add on if she has any further points to it.
I completely second what Surbhi is saying. We can't forget, we're not losing sight of Ghanshyam Mishra. That is still good law, whatever may have happened with Rainbow Papers. But we've also seen how the fate that Rainbow Papers has met in the review and so on and so forth. I think that there is a very strong view repeatedly the Supreme Court has taken that once a Section 31 order is passed, the plan attains finality. Even in Ghanshyam Mishra, there was some, it all got triggered by the Jharkhand electricity board making claims and one more operational creditor making claims. And I don't think the Supreme Court needs to go over and over it again multiple times. We need to accept the law for what it is. What an issue that I am facing in a matter right now is very interesting. There was an arbitration proceeding going on. The claim of the claimant's claim was admitted. That has been taken care of in the resolution plan. But the corporate debtors, now what has happened in light of the fact that the Section 14 moratorium and the claim of the claimant being admitted and taken care of, the corporate debtors counterclaim. Is that time barred? How do we deal with that? So that's an issue that one is, again, a logistical problem which one is dealing with, and I'm sure it'll get litigated at some point. It is about to be litigated. It is in court. But so I think there are some of these issues that remain, which again can be creased out with correct and effective judicial interpretation. I leave it to Eshna and Ishana now.
Sorry, I'm just going to share my PowerPoint before I say my thank yous. Is it visible?
We can see it.
Okay, perfect. Thank you so much. To start off, before the time clock is imposed on me, I wanted to say thank you very much to Insolvency Law Academy for making the technical aspects possible and also helping in putting together this particular webinar session debate and inviting me. I'm also extremely grateful for the International Women's Insolvency and Restructuring Confederation, the India chapter of which Eshna is a board member of, and has toiled away in bringing 4 minds of different legal spaces onto this particular platform. And thank you very much for inviting me. As the only teacher on this particular panel, I'm not as extempore as the rest of you, so I have a PowerPoint. So grant me the possibility of reading off a screen a little bit. And with that, onward to trying to respond to the great mind of Surbhi and Neeha and the difficult proposition that has been placed on my plate and table. Just to sort of go back to what Ishana has set the tone for in the first proposition, because she laid down all the case laws as the great litigators do. I wanted to go back to a little bit of a principle when it comes to understanding the position of disputed and uncrystallized debt and its position in bankruptcy and the manner in which bankruptcy has effectively transitioned into the law that it is in the Indian context. A very central proposition very early on, because of the nature in which the jurisprudence has already evolved, has been the trigger of insolvency and the crystallization of debt. Very important proposition, very first judgments in this particular instance, and then understanding the distinction between disputed debt and disputed claims in insolvency have been very foundational in establishing how our bankruptcy system will work. Innovative industries, I think most of us here are somewhat connected to bankruptcy studies, laid down the concept of having crystallized debt as a benchmark for triggering bankruptcy, right? And subsequently, Mobilox also put the position, which is another judgment, put the position of disputed claims in bankruptcy. Key point being disputed. I don't want to toot my own horn, but one of the insolvency resolution professionals of a big case that effectively reviewed the issue of notional value in disputed claims, which is the SR Steel case, which has been touted as an example again and again, which is Mr. Satish Kumar Gupta. And I had the privilege of writing on disputed debt from his perspective and in experience, and my perspective in terms of researching what the idea of a notional value would lead to and why it is so significant for a jurisdiction like India. It is very important for us to principally also understand that claims subsequently in insolvency need a consolidation platform, which is why the idea of a moratorium and a consolidation platform power of an insolvency professional was brought into the mix when it comes to implementing a procedural law like bankruptcy, right? The proof of debt, the idea of what a claim stands for. Looking at the SR Steel case or the Bush and Steel case, in both instances, you had notional value of unstamped operational creditor debt that was essentially introduced as an international principle, and the notional value concept has been laid down in international insolvency principles as well. Both of these introduced with the idea that there should be overarching clean slate, enforceability of a contract of restructuring, which is what a resolution plan is. And therefore, ultimately, as I've in an oversimplified manner provided for, the admission of claims therefore becomes a regulated method and not an arbitrary method. You do have one company, and this particular company has the option of a fresh start, a clean slate, so that it is treated, in fact, like a separate legal entity. Now, if no claims are raised, the position is clear. I think both Neeha and Surbhi have also acceded to the fact that Ghanshyam Mishra is good law. But what is the contingency then? And how does resolution plan contingency sort of play into modern day implementation of the bankruptcy code as we see it? Now, from the Indian perspective, I wanted to bring in a critical aspect of where judicial review and clean slate are tied together. And this is important for us to also review when it comes to the issues that cannot actually be provided for in a resolution plan, right? A resolution plan, by virtue, is a commercial idea of how you would restructure a particular debt, which is why a COC in its own right has the ability to effectively provide in a contract adequate protection as to what happens if the markers of a payment or markers of a reorganization are not met, which is why there is a flexibility in the manner in which distressed debt is structured in insolvency. You can use schemes of arrangement, which are out of IBC, almost unheard of when it comes to distress, or you could effectively review it through strategic M&A. You can also look at private equity as a particular investment. And therefore, it allows the aspect of future claims and contingent claims too, in fact, be covered. If we look at jurisdictions outside of the country, I hope I'm on the next slide. The aspect of contingency being real is considered through liability management that is introduced as a part of contracting or deal making. So here we need to sort of understand now in conflict with specialized laws, because we are sort of very mindful of the fact. Sorry, has my share screen gone? Apologies.
No, we can see it.
Okay, perfect. With sort of the aspect of arbitration and specialized laws, to ensure that there is, in fact, the idea of clean slate that is permissible to the extent possible, because ultimately, like I said, the idea is to make the contract of reorganization as enforceable as possible and therefore not carry the past baggage. However, it doesn't mean that there is no perspective of future claim that can be introduced into the contract or become subject to parallel perspectives locally or globally. Because you see here, to sort of introduce very briefly the principle of territorial moratorium versus worldwide moratorium, one must understand that future contingencies, parallel contingencies, are aspects that cannot be controlled entirely through contract. The Americans have introduced the principle of liability management into insolvency resolution. There is a future for of contracting that needs to be allowed in when you're looking at large scale FDI or large scale investments, funds and private equity contracts. You're already looking at insolvency as a keyed in contract, not just from the perspective of when event of default occurs, but when sort of your rights like puts and calls and future contracting sort of effectively is impacted when your company is in bankruptcy. These are nuanced distinctions. So the finality of a resolution plan is only final to the extent that what you have said you will do, you will do. The contingency that exists vis-a-vis claims to say that you can worldwide impose the clean slate is quite problematic from the perspective of a commercial document or a deal in itself, because ultimately what is a resolution plan? It's regulated deal making, right? That a bankruptcy court has been brought in with limited powers to know that there is equitable treatment. Videocon, for instance, is a highly problematic judgment at the end, because you are now looking at a court who's sitting down and saying that public interest will now become a marker for whether a resolution plan becomes final or not. So that is an overbreach when it comes to commercial interest. However, Having said that, courts have very actively, even in the videocon judgment, despite a reopening of the resolution plan, court has categorically said that, look, we are placed in a position where the COC has that commercial wisdom to reopen and relook on how you have treated certain vulnerable creditors, right? Now, in that context, coming back to the subject of parallel specialized laws, please understand one of the things that I want to put to the table is the idea of competing specialized laws and whether they are right in their own instance, right? The supremacy of a bankruptcy law is closely tied to the idea of how enforceable a resolution plan is. Arbitration is its own specialized law and has its own supremacy, has effectively been adjudicated and provided for in plethora of judgments, and courts have gone in and said that until and unless there is a true conflict, we will not provide blanket supremacy to an insolvency law over an arbitration law, which is not the case when it comes to PMLA. So the proposition vis-a-vis PMLA is slightly more confirmed as opposed to a commercial law like arbitration. So the question that needs to be understood is whether an arbitral award then, when your debtor has been resolved, really extinguishes. We do have judgments like the electric steel case in which it does happen, but one has to then further distinguish on whether it is a domestic award we're looking at or a foreign award we're looking at or a foreign creditor and what jurisdiction things in the particular contract apply to, right? There are nuanced distinctions that exist even today, and contingency of a claim, which goes back to the first principle. If it is contingent claim, it is not crystallized debt, it is triggered by virtue of a resolution, and the jurisdiction is not India. There is either effective provisioning in contracting that can mitigate that, or you litigate it in that jurisdiction and work it within the resolution plan. So in fact, a resolution plan in those circumstances can't have global reach. There are jurisdictions like Singapore who have reviewed worldwide moratorium and try to bring in global disputes, contingent future claims within their legislation and provided for it in restructuring. But we are at a very nascent stage, and only by reviewing certain kinds of principles that can impact a resolution plan or a reorganization plan and allow a COC that flexibility to effectively review them and treat them as private contracts, which is in fact what a resolution plan is, will a universal clean slate, which is what seems to be the agenda point here, can be achieved. If not, it is actually a myth and cannot be achieved in a deal-making scenario, which is what distress restructuring under the resolution of the IBC 2016 is. And with that, I would go over to the moderator, and I'm certain I'm within time.
You definitely are. But I've taken in what both sides have had to say, and it's actually brought me to the point of what was the point of the COC exercising commercial wisdom then? If at the end of the day, the plan was designed in a way that it was, it has its, to test the water tightness, I guess it has its leaks here and there. Some may say it's logistical, some may say that it's inherent and fundamental. But what happens to the commercial wisdom that we were so all told about had supremacy, had limited judicial intervention? I mean, we're seeing cases, I think Neha mentioned, and we also know about Rainbow. We have cases where there is judicial intervention asking applicants to comply with statutory priorities. I mean, are we still seeing this watertight resolution plan as if it were a surgical solution to corporate distress? Whether that's one way of looking at it, but whether the commercial wisdom and the judicial intervention to that commercial wisdom is what is going to now take supremacy in how we test the watertightness of this resolution plan. And that brings me to the third and the final leg of this discussion, is whether courts should be permitted to intervene with the commercial wisdom of the COC to ensure that statutory priorities and statutory authorities and secured creditors are treated in accordance with law. notwithstanding what the resolution plan says. And I open this topic I table this topic to the panelists now, and call upon Surbhi and Neha to speak for the motion, and will then call upon Ishana and Eshna to speak against the motion.
Thank you for that. I think that's a very important question today. Again, brings us back to Bhushan Power and Steel judgment, I think, because that's where it's really coming from. Commercial wisdom, one side, the role of courts, one side, effectiveness, watertightness of the resolution plan being the objective. I reiterate what I said in my answer to the first question, that no SRA today will come in who is not going to be absolutely clear on his plan, his financials, his mode of implementation. A, because a lot of time, energy, money is being invested, and B, there are consequences. Now, you're not going to go ask for trouble. The role of courts has to be supervisory, according to me, for the simple reason that we as practitioners of the law and even judges, while dispensing justice, need to understand that there is, and I quote from Justice Sikri's judgment here, where he said that every judicial decision has an economic impact. They're two very distinct disciplines, but they are intertwined. One impacts the other in ways we cannot even imagine. That's not the topic of discussion here. But having said that, judges, with due respect to them, and even us as lawyers to a large extent, cannot understand the financial or anticipate the financial nitty-gritties or the impact of even a certain manner in which money is to be raised, whether how it would benefit raising that money from an AIF versus a private equity versus a nationalized bank versus by an external commercial borrowing. These are vagary. We can broadly know about it, we can understand the theory around it, but the commercial reality and the functioning, only somebody from that sector will understand. So I think courts need to understand and realize, and we need to support that thought process, that there has to be, to make and ensure that a resolution plan and the intent, objective, and integrity of the code remains sacrosanct, remains workable. There has to be a thin line, a Lakshman Rekha, that has to be drawn, and the effectivability of the plan has to be judged at the COC level. I leave it to Surbhi if she would like to add something here.
Yeah, thanks. Yeah, I think a couple of points I wanted to add. I think right from law school, the way we've seen how courts have functioned, I think it's always important to have judicial intervention. I remember the days from basic structure, Keshwan and Bharti, when it came because of certain reasons, but we need to appreciate that courts have always tried to balance it out. Now, when it comes to economic legislation like the bankruptcy court, then we need to see, we need to balance out. I think what Neeha also said, that we need to balance it out. We need to see what should be the scope of judicial review. Completely ruling out the judicial review may not be the right solution, because they're not rubber stamp. They are judges who have far more wisdom than either lawyers or the commercial guys have. But at the same time, to rework the structure that has already been approved may not work. A couple of instances, for example, just to appreciate how courts have looked into it. I think one was when plans used to provide for everything under the sun and used to think that this is what will be granted by the court. That's when the exception for reliefs and waivers came in. Second aspect was unilateral termination of contracts. That is not something what a bankruptcy court can grant. And judges took cognizance of that and decided you cannot unilaterally terminate the plan by virtue of a resolution plan. Third aspect, termination of employee contracts. Now, that is something which is not sustainable. You cannot just say that from one particular date, all the workers shall, the employment of all the workers shall stand terminated. So these kind of points, I think specific pockets is very much appreciated. But at the same time, when courts go and look into, and I think what Neeha was also trying to highlight, that ECB regulations and all, and if you're trying to rework the commercial structure, that's where the buck needs to stop, and somebody needs to be told that this is not something that needs to go into. If it's compliant with the law, then let it leave it to the COC and the resolution applicant who have spent months, for example, to come up with a resolution plan to ensure that the company is resolved. So I think these are a couple of the points that I wanted to make for this particular proposition. Thank you.
Thanks, Surbhi. Thanks, Neeha. Ishana and Eshna, to you now.
So this particular proposition, Ishna and me have split into two. I'm just going to talk about the aspect of commercial wisdom, and I have a feeling that I can piggyback on Surbhi because she's actually been kind enough to set the tone in terms of favoring our proposition as well, which is quite fantastic. I'm so glad you're my friend also. And Ishna will effectively move into the aspect of statutory debt as well. Now, my understanding, just going back to administrative law, because Surbhi mentioned school, and I also realize it's been 20 years since I studied administrative law. But just to sort of go back to administrative law, one of the things that one of the papers that has been a hallmark of everything that I teach and also study is the paper on Fuller, which I've put on the screen. The idea of limiting scrutiny, judicial scrutiny, and saying that there should be limited judicial scrutiny in tribunalization is actually very key. The principle of rule of law that Fuller has proposed, which has become the hallmark of administrative law and powers of a particular tribunal, particularly commercial tribunals, have been very sacrosanct in terms of how tribunals in India were perceived, particularly commercial tribunals in India were perceived. Section 31 says very categorically there is a fair and equitable treatment that a court can review. Section 60 in its powers allows a tribunal to enhance its scope if there is same principles of patent illegality and public interest, which it has reviewed when it comes to Videocon. The positions that Surbhi has already mentioned in terms of unilateral termination, in terms of protecting vulnerable creditors, are concerns that courts have actively reassessed, including, say, dissenting creditor rights, which are not built into a bankruptcy code, unlike the provisions of the US or UK. Now, in its super sort of simple majority vote model that the IBC evaluates, the role of a committee of creditor is to ensure that there is that equitability in a plan. And equitability is quite different from fair and equal. And the role of the judiciary essentially has been therefore limited to note whether certain markers have been particularly met or not in a particular plan. And there have been instances where those markers have perhaps not been as per a particular court's understanding of a Section 30, right? And we're only talking about a resolution plan and how the intervention of a commercial wisdom essentially needs to be assessed when a court is reviewing a resolution plan. In most instances, because we only speak about cases where there has been scrutiny, in most instances, courts have been very on point when it comes to saying that commercial wisdom has been exercised and we don't see anything problematic with a particular resolution plan. And we have to appreciate that. The principle with which a commercial tribunal was in fact created has actually been upheld time and again by the tribunals and by the courts, the appellate particular structure courts, the ANCRAT and the Supreme Court. However, the enablement of a commercial wisdom becomes sacrosanct and very necessary for us to understand. Just saying COC has commercial wisdom is not sufficient to actually give that COC commercial wisdom. There are markers that need to be understood that yes, there is a resolution plan that a COC negotiates. There is a control that it exercises for a resolution professional to effectively asset preserve, debt organize, including issues, say, of interim finance, which is a very large debate that we don't need to get into here. But the efficiency of a bankruptcy regime is enablement of that commercial wisdom, allow an enhanced private marketplace solution for both public and private debt. It cannot be singularized to public debt only or to private debt only. One of the instances that I've had the opportunity to work very closely with is the notion of what public debt means. Yeah, is it a public sector bank debt, or is it the debt of workmen, or is it debt of state government authorities, right? There is a nexus of contracting that COCs have exercised. For instance, in Bhushan Steel, there were a lot of trade union debt that was negotiated. There was a lot of statutory liability that was negotiated as a part of the resolution plan. So there is the openness and exercise of that commercial wisdom that COCs have demonstrated. But increasingly, if you review vulnerable protectors singularly, which even in Videocon has been done, you are reviewing a perspective or allowing a perspective because courts are sacrosanct in India. You know, you need courts to say yes. If courts say that this is not okay, then it opens a different can of worms for all in all matters, where every sort of person who has right now not made that application on ground of it being thrown out by an NCLT has that proposition of litigating a particular right, especially when you're looking at inter se rights, especially when you're looking at creditors in same class pools who are not happy with the 51% vote. And that becomes problematic. Even at a monitoring stage, it cannot be scrutinous for a court to say, hey, COC, please take care of the commercial wisdom. It should not be should not be so. COCs should be empowered enough to effectively take on that option themselves and see that a resolution plan is not being implemented and therefore redecide for a liquidation with, of course, the approval of a timeline from an NCLT with a yes or no model. It cannot become a litigious standpoint again. And to penalize resolution applicants on their own, right, for not being able to pay up, and a COC in itself not being able to trigger the performance bank guarantees, etc., is a different perspective that needs to be evaluated. Why is that happening? It is a deal going wrong, ultimately, right? Why should it need the imposition of costs or the imposition of a court to effectively say this is extremely problematic? And with that, I want to say that the commercial wisdom of the COC has to be re-enabled. Allows your committee of creditors and your RP the opportunity to renegotiate a deal that has taken so long to be able to reorganize and bring to the table. Because we cannot place our bankruptcy law in such a over-regulated method where without a court saying yes or no to any form of change, you cannot move forward or actually reorganize. This is detrimental to asset preservation because asset preservation needs to continue even after a resolution. For some reason, the perspective has shifted to say once a resolution plan has been passed, an asset is already preserved. That is not the case. The work just starts when a resolution plan is passed. And that needs to be considered as a very significant step to the economic enhancement of a bankruptcy law. And with that, I've given my co-speaker very little time. Ishna, I'm so sorry.
You've set the stage for me, and I absolutely agree with all of that you've said. And I just take a cue from there that when we're looking at commercial wisdom of the COC, we're actually looking at a deal, or what we call in very, very strict legal terms, if I may say, a kind of settlement which is happening out of court with a discussion, which is very different from an adjudication by a court of law, which we always read when we look at the difference between, say, arbitration and court proceedings vis-a-vis mediation or conciliation. I say it exactly like that. And therefore, the commercial wisdom of COC is sacrosanct, and the manner in which it has been done away with in Kalyani Transco is something that needs to be brought back. However, coming to the issue of the judicial review relating to statutory debt, I believe that is one of the biggest leakages that a resolution plan can have. And Surbhi very, very sweetly puts it as pockets, but I look at it as a big leakage. Reason for that is that if a resolution plan is given and the resolution applicant has decided what is the kind of value that it is allotting to each of the creditors, it is not possible for it to then later come to, a position to pay more. Like the rainbow judgment, even when it came, it did not clarify that it was only prospective. It really, really, kind of trampled on all the resolution plans that were pending before the Honorable NCLT or the NCLAT, wherein anything that was in the books of account for which claims had not even come in, there was a treatment that had to be given. And the resolution applicants are usually faced, and those are still pending, I think. And the resolution applicants are usually faced with a situation where they can't even withdraw because of EBICs. So we have a non-withdrawal by the SRA, and if withdrawal done with implications, and on the other hand, being imposed with crores of rupees to be dealt with. And of course, all of this started from Rainbow, went on to Greater Noida versus Prabjeet, where in case of Greater Noida, land areas were recognized as being secured creditor under Section 13 and 13A of the UP Industrial Act. And while dealing with the JP matter, we were faced with the same situation. NCLT approved the resolution plan. The rainbow judgment came in between NCLT and GLAD. YEDA, that is the Yamuna Expressway, questioned this very fact before NCLAT and objected to the plan, relied on Greater Noida versus Prabjeet, and Suraksha had no option but to give the entire money to YEDA. And very interestingly, because the law is still gray on this, as to whether one creditor can be a secured creditor as well as an unsecured creditor, today we are back to that same position of the commercial wisdom of COC being tinkered with right there, that even if a claim has been given as an unsecured creditor, as a mere operational creditor, it is being allowed to be changed by the court as a secured creditor. And that just jumps the entire class under 53 over and above the financial creditors. So I believe the legislature, by commencing that entire review from Rainbow, has actually, what I look at it is like a judicial activism, because crown debts are clearly said to be under 53 below the financial creditors. So to give them a status of a secured creditor merely because of the fact that their own law states that, and this is despite 238, and this is despite the fact that the opening of Section 53 is also a non-substantive clause, I think is incorrect. And with that, the uncertainty seems to just be increasing. And I think that is the prime reason that we see companies rather being pushed to liquidation today rather than resolution. So with that, I say that the fact that modification of resolution plans, withdrawal of resolution plans are something that are not allowed, but modification is imposed because of judicial review. Therefore, judicial review for statutory debts, including EPFO or GST, should not be allowed. And that is why, because it's being allowed, today a resolution plan being a watertight one is really a myth.
Thanks, Eshna. Thanks, Ishana. And I think if I can just quickly summarize this, is how we started. And if we look at it from a very textual context, we have the process of resolution plans starting from Section 31, which talks about approval and makes it sound like it's sealing the deal. Then we talk about what happens in practice. We spoke about the debate on the sufficiency of safeguards under 32. We spoke about clean slate theory in the context of contingent claims, liabilities, including arbitration proceedings. And then we spoke about the concerns with judicial intervention to the COC's commercial wisdom. With these experts and great minds giving their views on this, I will now open this topic to the vote of the audience. Ishana, if I can just ask you to put up the first slide, which sets out the proposition for our listeners to see. And just dwell over everything that has been said and vote on whether a watertight resolution plan is a myth or a reality. If I can request all the people who have joined the call, all the participants, to just put in the chat box just the word myth or reality, so that we can have consensus on what everyone thinks. This will also just be a test of whether anyone or everyone has been listening in at all. And also for you to know that you were not just listening into the debate, you were part of the people shaping it. So we would like to hear what your views on it are. We only have one person who's responded, and I'll urge everyone else to give their views as well. I think we'll give it another minute, and with that, we'll just take a count of whoever has put in their votes. I can see some people feel so strongly about it that they're voting twice. They're like, they doubly want to ensure that we know if it's a myth or a reality.
Let's count that if they say myth.
Okay, done. And we'll let it go if this is a reality. Okay, we'll give this 30 more seconds. Does anybody else would like to give in their view? Okay, I think we will close polls for now, and I'll request Vaidehi to just take account of the votes that we have. Till she's doing that, I will just open the floor for closing comments, just 2 lines from everyone. And I will request all of you to remove your hats of whether you were for the motion or against the motion. And in 2 sentences, if you could just answer the proposition on whether a resolution plan is a myth or reality, of what you truly feel and not what the debate has asked you to speak about. We'll start with Ishana.
I was thinking 2 lines. That's 2
Okay, we
lines.
can start with Eshna and come back to you.
No. Just to sort of, I wanted to not perhaps summarize, but I wanted to surmise a very significant point that Eshna spoke about. And I think there is a bit of a differential view there. The idea of statutory debt actually needs to be understood and refined, right? And I want to go back to the 1913 law, Companies Act, which essentially gave super priority to government debt. And the reason for that is to evaluate what the meaning of government debt is, right? One must understand that public sector banks are also sort of government debt. They are, in fact, public sector, not pretty much by definition, but one must understand that. And when you're looking at government debt, as in principle, central government debt and state government debt are very different stakeholders in bankruptcy. There are cases and instances where, say, water pollution control boards, which have allowed factories by virtue of employment continue, but have shut them down when there are going concerns in insolvency, and therefore asset value is dropped because there is no settlement possible for state government authorities. So a re-evaluation of what this government debt means becomes necessary, and whether there has to be differential treatment can be supported if commercial wisdom is enabled further. And there have been instances where there has been that priority of settlement that has been provided. And that, I think, still should be on the legislative or policy agenda of assessment. Because despite sectors, while sectoral bankruptcy has its own challenges, state debt does not have sufficient evaluation just yet when it comes to resolution plans. And it seems to be an increasingly concerning proposition for the implementation of the bankruptcy law as is. That's the last controversial point, not 2 lines, and over to the rest of you.
Eshna, 2 lines from you, please.
Yes, thank you so much, Vishshrutyi, for moderating this so well. My thoughts on the entire process is that though we have a specialized tribunal for this, we still do not have specialized experts for this. The fact that we are before courts who do not understand the entire regime to its maximum, level that is required. And like, Ishana traces it back to the history, that history is also not probably known to them. And I don't say it only at the tribunal levels, I also say it at the high court levels. Like we've got a commercial court in the Delhi High Court. I believe that the entire difficulty is because of not having those experts there to understand what the law is and how the law is to be, carved out in order to ensure that what Surbhi and Neeha earlier said, to balance out the commercial aspect with the legal aspect, because it is something that is very, very sensitive. So I think despite all the issues for and against the resolution plan, whatever we've discussed and much more there are, I believe it is important that the law finds its way in a manner that really looks at not merely the interest of the stakeholders, but also looks at the law in a manner that it really touches upon the intent of it. So mine is more of a logistic view right now. I would like to close it on that because the issues are quite pertinent, is what I feel.
Thanks, Surbhi. Thanks, Eshna. If we can have 2 lines from Surbhi, please.
Thank you. I think before I go on my views, I think the most beautiful reality has been an all women's panel. It's very, very interesting to hear from all of you. I think I'm an optimist. I think it's a reality also because we have come so far in 10 years that most jurisdictions have struggled. They've had like very evolved jurisprudence, yet it took them 100 years, but we have accomplished a large part of the track in last 10 years. I do believe that there are different participants in the process. There will be an interplay and this struggle does continue, but we have set down law on various issues. Something like clean slate theory came as soon as in 2018, which is commendable. And I do understand that there are challenges, practical challenges, but I think we are evolving, and I do see a bright future ahead when it comes to the restructuring and stress asset regime in India.
Thank you. Last words from you, Neeha.
Thank you, and I totally agree. It's actually refreshing being on an all women's panel, quite liberating in a manner of speaking. I do stand by my position that I think that we're working towards a reality where resolution plans can and will be maintainable and sustainable and will be functional. I think the intent is there. We are on that road. There are hurdles, but then those hurdles come with just about anything. In the early years of uh, the insolvency code, the number of amendments, even by way of um, the ordinances that we saw, the whole idea was to make it as workable as possible, as effective as possible. So I do personally believe that resolution plans are effective and they are a reality.
Thank you so much. I think we have the votes are in, and I think I know what the results are, but I'm going to let Vedi, who's the convener, if she could just tell us what the final outcome is.
Yes, so we have like 6 votes saying it's a myth, and excluding one, which is a mix. So we can say like we got 3 as a reality.
So here we go. That's what our audiences had to take away from it. And with that, we come to an end.
I think the pain is real, Vishshrutyi.
It was I mean, one thing that this debate has shown that the watertight resolution plan may just be a legal aspiration, but it still leaks in practice, or as Neha put it, in some logistics that we still need to work around. Thank you so much again, panelists, and thank you for everyone who joined. Thank you again to ILA and to IWIRC. For those who may not be familiar, IWIRC is a global network dedicating to advancing women in the space of restructuring and insolvency. And the India Network has been contributing actively to thought leadership in this space. As Ishana mentioned, Eshna is on the board and has been leading the way to this network. Thank you again, everybody. Thank you, Vaidehi, and thank you to everyone. Have a great evening. And we hope that we've left you with sharper questions and a few less myths that we all had before we joined the session. Thank you so much, everyone.
Thank you. Thank you.
Thank you. Thank you so much.
Thank you.